Friends, I'm happy to share with you another episode of The Lighthouse, Talks with our India experts. Do feel free to share your comments and please hit the like button. Stay tuned and stay connected.
Welcome back to Rural & Partner presents The Lighthouse, Talks with our India experts. In this episode, we aim to decode alternate dispute resolution mechanisms for speedy and cost-effective resolution of commercial disputes in India. In today's session, we have with us Vaibhav Sharma. He is a senior professional at Rural & Partner and a qualified lawyer and company secretary. Vaibhav has an expertise in handling wide variety of civil disputes, arbitrations, conciliation, and formulating litigation strategies to safeguard commercial interest of clients. Welcome, Vaibhav.
Thank you, Anushrii. It's a pleasure to be here today.
Thank you so much. Vaibhav, as per the national judicial data, more than 1 crore civil cases are pending in Indian courts, and knowing that litigation is such an expensive and a time-consuming affair, what ADR mechanisms are available in India?
See, you have rightly pointed out the situation of Indian courts, and because of this reason only, businesses are now exploring the alternate mechanisms available in India to resolve their disputes in an expeditious manner. Arbitration is the most commonly followed ADR mechanism in India. The difference between an arbitration and conventional methods of litigation is that in arbitration, the strict procedural rules of India are not followed. So the proceedings are very flexible in nature. Having said that, the award of an arbitration is as good as an order passed by a civil court. Lately, arbitration has become a very costly affair in India, and because of that reason, conciliation has become a new favorite. In conciliation, the conciliator role is to bring parties together, understand their problem, the dispute is between them, and try to propose the settlement terms. Conciliation proceedings are privileged in nature, which means that these proceedings cannot be referred to or rely in any other forum by either party. And conciliation proceedings are voluntary in nature. Either party can withdraw at any stage. Lately, after 2019, we have seen the trend that mediation has also emerged as one of the popular mechanisms in India. However, in mediation, the role of mediator is very restrictive. It neither adjudicates the matter like an arbitrator, nor it proposes the settlement terms like a conciliator. The limited role is to bring parties together, try to establish a chain of communication between them, let their emotions speak, and if the parties could resolve the matter, then ensure that they sign a consent terms which is binding in nature. So which is why it is said that the mediation matter gets dissolved and not resolved. So these are the prominent mechanisms available in India.
That's very informative. What reforms the present-day government has brought in for doing ease of business in India?
Anushrii, that's a very important question you have asked. See, in 2018, the present government has brought an amendment in commercial laws which requires parties at dispute to first exhaust conciliation to resolve their disputes. If the conciliation fails, then they can escalate the matter to a civil court. In fact, I have assisted one German supplier company to resolve its dispute with Indian distributor within a short span of 6 months. Besides that, the Indian government has also established a facilitation council for micro, small and medium enterprises to help them in resolving their disputes through conciliation. However, if conciliation fails, then facilitation council itself refer the dispute to an arbitration. The window period for completion of that arbitration is 90 days. I would also like to inform that India is a signatory to Singapore Convention on Mediation, and it aims to develop an ecosystem for mediation. And in 2021, the Indian legislature has passed a bill on mediation whereby the Indian government shall establish the international mediation centers in India.
You mentioned that arbitration is the most commonly adopted ADR mechanism in India. So how is the arbitration ecosystem in India?
See, Indian arbitration law is based on United Nations international trade laws to bring it in alignment with international arbitration laws. See, almost all sorts of contractual disputes are arbitrable in nature except where the right and rem are prejudiced, like copyright infringement or where serious fraud allegations are involved. So far as the procedure is concerned, as I said earlier, parties can in consultation with arbitrator frame the rules of arbitration. And I would like to mention that India is a signatory to New York Convention on Arbitration, and which is why it recognizes and enforces foreign award as if the same is passed in a domestic arbitration. And if someone asks me how much time it requires to conclude an arbitration proceeding, I would say in my experience it generally takes 1 year to 1.5 years. And apart from that, I would like to mention that the present government is much emphasizing upon developing institutional arbitration in India so as to make it as an arbitration hub like London or Singapore. And with that aim, the government is developing international arbitration centers in New Delhi, also in Gift City situated in Gujarat, to cater the disputes which are arising out of foreign transactions. So that is the mechanism available in India for arbitration.
Everyone today is talking about artificial intelligence. So what role could AI play in designing the future of ADR in India?
See, that's a very interesting question you have asked, Anushrii. In my opinion, AI has a long way to go when it comes to its application in judicial system in India. Having said that, steps have already been taken in this regard. In 2021, the Planning Commission of India has proposed a policy framework for developing online dispute resolution, whereby the matters where stakes are not very high could be resolved with minimum intervention of humans. Besides that, in 2020, the government has brought certain amendments in consumer laws, whereby now e-commerce entities are mandatorily required to provide an online grievance redressal mechanism to customers. So definitely we see that in coming years that AI will only supplement the judicial system, more ADR mechanism in India.
That's great to know. In your experience of this field, Vaibhav, what advice would you like to give to our viewers for speedy disposal of disputes?
I would say better call Rodel.
Yes.
See, it all depends upon your strategy. In one of the matter, I advised to one of our client to sort their recovery matter with their debtors by filing a liquidation application. Resultant, the debtor came forward and resolved the dispute because he could not have afforded liquidation of its business in India. In several other matters, I have mediated the dispute between the contractual parties, and that could help them to save enormous amount of litigation cost. So the mantra is that party should first explore the alternate dispute resolution mechanism available in India before resorting to civil courts. And that is my also opinion to our viewers.
Thank you for this wonderful session, Vaibhav. I'm sure this session will be very relevant for our viewers who possibly face dispute situation.
Thanks again, Anushrii, for having me here. I would love to answer queries of our viewers in this regard. Thanks.
The contact details of Vaibhav are given in the bio of this video. Dear viewers, we would be delighted to remain connected with you via Rudel & Partner presents The Lighthouse, talks with our India experts. Thank you for watching our today's episode. Please be safe, grow your business, and play by the rules.